Hi, Will. Hi, Simi. Welcome.
Hi, good to see you, Simon.
Yeah, good to see you, Simi. Thank you. And welcome to everybody joining us. My name is Simon Nicholson. I'm co-director of the Institute for Carbon Removal, Law and Policy at American University in DC. Thanks for joining us for this installment of our Scrubbing the Skies webinar series. The topic today is the potential role of BBNJ, which is the Biodiversity Beyond National Jurisdiction Treaty in ocean-based carbon dioxide removal. We're joined by two oceans international law experts. My colleague Will Burns, who's the co-director of the Institute with me and normally the host of these webinars. We've given him release for the day so that we can pick his brain on this subject matter. Will is also a visiting professor at Northwestern University in the Environmental Policy and Culture program. And Simi Payne is associate professor in the Department of Human Ecology at Rutgers University. And amongst other things, is also chair of the Ocean Law Specialist Group of the International Union for Conservation of Nature. So, Will, you have to set this up for us. What is this BBNJ that you've brought us to talk about, and maybe relationship to the Law of the Sea Convention? Anything else just for context to get us started?
Yeah, so let Simi, since she was intimately involved with the negotiations, set the table a bit about the negotiating history, but I'll say a little bit about its relationship to the Law of the Sea Convention. So the Law of the Sea Convention, after protracted negotiations, was open for signature in 1982. And it was denominated at the time the Constitution of the Oceans, right? It's a comprehensive framework to regulate all areas of the oceans, from the territorial seas through the high seas, and it encompasses aspects of military considerations, exploitation of minerals, as well as what may be most pertinent for today, marine environmental protection. And then this new treaty is the third what's deemed implementing convention or agreement under the treaty, which are agreements that seek to extend the scope and breadth and clarify provisions of the Law of the Sea Convention. The first two were one on deep sea mining, and then another one on straddling fish stocks and highly migratory stocks. And this was the third agreement of that nature.
Thanks. And I guess it's obvious to folks who are tuning in that the reason that we're bringing this up, the conversation, is because there are so many marine carbon removal proposals now on the table, different ideas being explored. And so, Simi, to get us into that conversation about the relationship between this new treaty and carbon removal, can we just talk some about the negotiating history and how we got here?
Sure.
Yeah.
So I guess to start with, there really wasn't a focus on climate intervention technologies driving this. This began a long time ago, this negotiation, about 20 years ago. And the negotiating process, and my favorite article on it is called The Long and Winding Road. So about 20 years ago, civil society observers, including my friend Christina Gerda from IUCN, called for the international community to protect ocean life. And, you know, you got to bear in mind, the oceans cover more than half the surface of the planet, about 70%. And 2/3 of that area is in what we refer to as beyond national jurisdiction. So there's, you know, land masses that are all basically countries, and then 200 nautical miles out is considered areas where those terrestrial bodies have some control. Beyond that, it's a shared ocean. So there's less regulation there. There's very little regulation there. And there's little means to cooperate and how to manage it. So it was a recognition that we needed a means for multilateral cooperation, all the ocean users, and ways to actually do integrated management of the activities that would be happening there, rather than treating each industrial sector separately. For instance, we have the International Maritime Organization that regulates shipping, but it doesn't look at all aspects of this vast ecosystem that's so important to the planet. So 2004, the United Nations, so a few years later, the United Nations General Assembly created an ad hoc, open-ended, informal working group, catchy name, to study the issues. And then that group, about 7 years later, came up with what was called the package deal. And the package deal brought together the interests of developed and developing countries. And so there's 4 elements in the package deal, 2 for each, if you will, although everyone has shared interests. So marine genetic resources, they're incredibly valuable. All this life in that ocean has genetic material that can be of great interest for pharmaceuticals and other products. So fairly dealing with that, so that developing countries, without the technology to exploit it, but with property rights of a sort, should be able to benefit from it. And I think in thinking about climate intervention, we want to be very conscious of that biodiversity and its value. And I'm not going into detail on that, although I thought that in the podcast series that the Institute does, Jessica Cross and Lisa Levin did a particularly nice job of talking about those aspects. So I'd recommend that everyone listen to those. So there's the marine genetic resources, which we're not going to talk about too much today beyond that. Area-based management tools in marine protected areas. The treaty provides a means for those to be established in these areas beyond national jurisdiction. That never existed before. The third element is environmental impact assessment. And the fourth element is capacity building. So sort of 2 conservation tools, 2 equity tools, if you will. Finally, this took a while then. That's the package deal, 2011. It took another 4 years before the UN General Assembly launched the negotiation, first with the preparatory committee, which met for 2 years, was supposed to come up with a 0 draft. So much conflict over different aspects of it that what was produced was a consensus document full of disagreement. That was sort of how they resolved that. And then it was supposed to have 2 more years of negotiation, but the negotiations actually didn't conclude until March of this year due to COVID-related delays. So a text was agreed after a marathon 36-hour negotiating session in March, adopted in June, and then open for signature in September 20th. And in that first week that it was open for signature, 81 states, the European Union, and Palestine all signed, which is an important step.
Thank you. Thanks for that context. And you opened what you just gave us by saying that climate intervention, including carbon removal approaches, were not really discussed in the negotiations. Did I catch that right?
Yeah, and this will be one of the tests of the agreement, how well it works for the particular issue that the Institute's dedicated to and that we're talking about today. And, in 2011, 2015, that was not at the forefront of people's mind. The greatest threat to ocean biodiversity is actually fishing. Overfishing, illegal fishing, unregulated fishing. The prospect of deep seabed mining is also a very important consideration. And then other activities like shipping that have serious impacts on ocean life. That combined with climate change and land-based pollution are what has created this fragile state. And that was really the focus of the treaty as it was negotiated.
Thanks. Let me just say to everybody who's tuned in, if you have questions, please use the Q&A function to start dropping those questions. I'll guide the conversation for just a little longer and then turn to questions from the audience. So given Simi's setup, why did you think this was worth us talking about? So maybe the way into that is there something here that those who look at marine carbon removal in particular should be interested in or concerned with?
Yeah, I think there's a lot of potential for this agreement to do something that hasn't happened to date, which is to create a framework for assessment and monitoring and transparency of marine carbon removal as it moves forward in a way that I think could ultimately be salutary not only for interests in these areas that might be potentially negatively affected, but also could be salutary by creating a guidance for those that are conducting these activities, including those engaging in research, whether it be university-based research or private sector research, and potential deployment in a way that does not exist now, right? And so one of the things I'd emphasize at the outset is that this treaty is particularly clear in according the Conference of the Parties a lot of discretion in terms of ultimately fleshing out this treaty and highlighting additional issues, right? And so what I would contemplate is that as part of that kind of organic process, as marine carbon dioxide removal research and potential deployment ensues and becomes larger in scope, it may be that the Conference of the Parties ultimately take this up. And so Simi had mentioned that there's four, major parts of this package, and I just want to talk about one of them that I think could be particularly pertinent in the context of marine CDR, and that's the provisions for environmental impact assessment and strategic environmental assessment, which I'll define in a moment. So under customary international law, it's already recognized that countries are required under some circumstances to conduct environmental impact assessments for activities that could have substantial or significant impacts in the marine environment. But that's pretty vague, right? And it's largely defers to national governments to establish the contours of what would be done. The BBNJ, in my opinion, really helps to flesh that out and maybe more importantly, provide substantial amounts of transparency and ensured sort of due process for those that may believe that their interests could be impacted by these kinds of activities. So there's a provision that says that states that have jurisdiction over activities in areas beyond national jurisdiction have to engage in an initial screening process to determine if the activity might have more than minor or transitory impacts, right? And then if in that screening process they determine that it would, they're required to engage in an environmental impact assessment to see if it could cause substantial pollution or harmful changes to the marine environment. That initial triggering also occurs for activities that are quote unquote have effects that are poorly understood. And I think that would be really pertinent in this context, right? Most of these MCDR field experiments that may ensue largely grow out of mesocosm and lab experiments and are highly freighted with uncertainty, right, in terms of what their impacts would be, positive or negative, in the marine environment. And so it's likely, I think, that most activities of this sort, any kind of proposed field experiment, would clear that initial trigger in terms of the screening process and require an environmental impact assessment. That environmental impact assessment has a number of components that are outlined in the treaty far more clearly than what we've had under customary international law and under the Law of the Sea Convention. And it has a number of guardrails to ensure that the world community gets to provide input into the process. It requires that information be provided to other states, especially particularly affected states, or ones that might be potentially particularly affected by this process. It requires that this information be provided in what's called a clearinghouse mechanism, which is established under the treaty to ensure that there's information on activities that are occurring in areas beyond national jurisdiction. And it mandates that input from affected parties be taken into account, responded to, and it provides that the scientific and technical body of the BBNJ, which can staff up with a team of experts, which presumably could include experts in this area, also gets to provide input on the environmental impact assessment, and a requirement that it be responded to. It also requires for ongoing monitoring and assessment of impacts, which I think could be particularly important when it comes to this, and reporting to the parties. And then finally, it has a provision for what we call strategic environmental assessment for quote unquote plans or programs. And if ultimately we were to establish, I think, marine CDR as a large component of our response to climate change, that would clearly be deemed a program or a plan, and it would require a detailed sort of assessment of kind of that ongoing role, as well as interaction with other programs in the area. And in that case, the Conference of the Parties would also have the right to conduct their own strategic environmental assessment. And so even if individual countries that are engaged in marine CDR or regional bodies didn't do so, the Conference of the Parties could do so, and help the world community kind of determine what role MCDR should have in climate policymaking.
Okay, so that's a lot.
Can I add a bit more?
I see the relevance. Yes, Sammy, do you want to add just some more context for us? And then I just want to test. So I'll plant the question just so you have it in your head.
Mm-hmm.
If I'm part of a startup enterprise, a company here in the United States that's looking to advance a marine carbon removal approach, how is this going to impact my work? And maybe we can kind of build to that through the other things you'd like to add.
Yeah, and I think so. That's a helpful question as kind of a setting of part of the framing here too. So I'll step away for a moment from the text, and I'll put on my hat as a law professor and just remind those who aren't lawyers that when you have an international treaty, that for the most part, I mean, a ceasefire agreement between two governments, we can think of a couple of those we'd like to see, are just between the governments. Good. But for something like this, environmental treaties need implementing legislation in national law. So a company will be affected by the laws of the country where it's based, or there can be other connections between the company and the country that will regulate it. But that's where you're going to be looking for how you're going to be regulated. A company won't be directly regulated by this treaty. So that maybe partially answers the question. But then functionally, let's assume that the treaty's in force, and let's assume that as with the climate change agreement or with the Convention on Biological Diversity, that it's a universal treaty and all countries are parties. Okay, so that takes away one of the questions. Then how is the substance of the treaty going to affect you? Well, as Will just described, the environmental impact assessment provisions will apply to you if your activity either is taking place in area beyond national jurisdiction, we'll say roughly the high seas, so that's technically not quite accurate, but that's what we're saying these days. In that case, we're thinking that it's the airspace, the water column, and the seabed are all within that, okay? Now, what if your activity is taking place within national jurisdiction, within that 200 nautical mile zone that I mentioned? It still might be covered if it's going to have an effect on areas beyond national jurisdiction, but the legal framing is a little different. But you'll still have some environmental assessment obligation. You'll still have monitoring obligations to ensure that whatever was predicted in the EIA is actually kind of what we're seeing as the project's going on. Now, you'd see that if you're doing the work in the US or the EU or almost any country in the world, you'd have this kind of obligation. The details are the details, but I won't go into those at the moment. I think a couple of other things. I think one thing that's really important that happens with this treaty that Will also alluded to is that for the first time, it provides an international forum and mechanisms for multilateral cooperation on ocean governance. And I think it's worth remembering that it's not just, a primary purpose is conservation of this incredibly important biodiversity, which is part of, the biophysical interactions in that ocean are part of what sequesters carbon and protects us in the natural system. So incredibly important. But it also can help prevent, you've got a research project that's been approved. You've shown that it's not going to harm the ocean ecosystem. And then do you want a shipping route to go through your research site? Probably not. So that could be another function of the kind of planning that could come out of the strategic environmental assessment process that Will just described. So that kind of deconflicting activities. The area-based management tool, marine protected area function they're flexible tools that are going to help us. This is a process that's already underway, will help us to identify particularly valuable and fragile parts of that ocean ecosystem, to understand the connectivity between different parts so that we don't inadvertently, say, well, here's a marine protected area, but have something adjacent that is going to harm it. So that will be a process that will be very valuable for figuring out where, if anywhere, climate intervention research can take place and potential deployment. I think another element here that's also very important is this introduction of equity. And that includes, the treaty includes tools to build capacity in developing countries, both in marine science and which will help with the equity aspect of climate interventions, but also in the governance aspects and participation in the treaty. And I noticed that there was also a question about the role for civil society, public participation in EIA. And there are provisions in the treaty in different points, partly through things being published publicly on the clearinghouse mechanism, like environmental impact assessment consultations, final reports, monitoring reports, proposals for marine protected areas, consultations on marine protected areas. There's a lot of that is anticipated. Personally, I think that that's going to require civil society to watch like Seahawks, to really make sure that happens, and to make sure that it's done well and done right, and to use that information to advocate, because, this is different from land. You don't have a lot of people living out there to defend these environments. So thanks for the question on public participation, because that's going to be critical.
You unmuted there, Will, as though you want to jump in. Okay,
no.
So let me just dive into the questions here. We've got a couple of questions that are asking us to zoom back out and set a little more context, and then a couple of questions that want to drill down a little bit on the EIA provisions. So the zoom out question for you, Will, are people proposing open seas marine carbon removal developments? So to say that in a different way, are people imagining dumping stuff into the oceans beyond national jurisdiction? And is that a differently regulated space, is the question, from the seashore around the country?
Yeah, it's a great question. Well, it's kind of both. As Simi suggested, there are environmental impact assessments for activities under BBNJ. There are environmental impact assessment requirements for activities that would occur within 200 miles if it could potentially have impacts in areas beyond that, right? And some of the things that we're looking at, enhanced ocean alkalinization, for example, or macroalgae sinking, could clearly have impacts beyond EEZs, right? And so there could be environmental impact assessment requirements. There are proposals for activities in the open oceans, including a lot of proponents of macroalgae harvesting or seaweed farming ultimately believe that if you're going to get to the gigaton scale or beyond, you're going to have to look at doing this in the open oceans also, because of the conflicts with other activities in coastal areas, and also the fact that the National Academy of Science said that even if you were to seed an area 100 centimeters all over the coasts of the world, you'd only get about 1/3 of a gigaton, right? If you're going to make macroalgae harvesting work at a gigaton or multiple gigaton scale, you're going to be looking in the open oceans. And so there are people that are talking about doing that. Some of the proposals involving upwelling have also talked about looking in the open ocean. So I think that's an area that we will definitely be exploring. And some of the early field experiments in the context of seaweed harvesting already have involved or contemplate in areas beyond national jurisdiction.
Thanks.
It's especially troubling. I think I would have heard people in industry say, and it's okay because there's nothing out there. And that is so far from truth. And if you're thinking, even if you don't want to think about it in ecocentric terms, in anthropocentric terms, remember that is the one carbon pump that we know works. Don't break it.
Well, there's one question here that says maybe there might be positive impacts of marine carbon removal developments. Are those sort of positive co-benefits or other impacts accounted for in the way that the environmental impact assessment mechanism is being set up?
Well, do you want to take that, or should I?
I could start, Sylvia. I know you have thoughts on this too. So, this is one of my soapboxes. I mean, a couple of things. First of all, BBNJ in kind of overarching objectives includes efforts to improve conservation of the marine environment, right? And so one could certainly make the argument that if MCDR activities are ultimately going to help us directly address climate change, which obviously has huge potential negative impacts, already has negative impacts in the world's oceans, as well as in some cases helping us to ameliorate ocean acidification, then clearly you could argue that those activities comport with that objective, right? In the context of environmental impact assessments, the problem I have most with environmental impact assessments is that they often don't facilitate comparative risk assessment, right? They have us look at the potential harm of activities without really being able to realistically weigh that against the potential benefits, and it's almost a one-way sort of ratchet, right? If there's any potential harms, then it heavily weights against that activity proceeding, right? I think with these kind of interventions, which are different than, for example, dumping of materials into the ocean just to dispose of them, These kind of activities where the intervention is designed to facilitate positive things, we need to be able to incorporate that into environmental impact assessments and try to engage in some kind of weighting, right? At the same time, the environmental impact assessment process does provide that you're supposed to try to ameliorate any negative impacts, right? And as a number of provisions for that. But I think that it would be beneficial to have more of an emphasis on looking at the potential positive impacts of these kind of interventions, and that might require a new mindset. Even people like EPA admit that when we're starting to look at proposed marine geoengineering activities off the U.S. coast, they will openly admit that they're largely a pollution-based regime that's supposed to look at the harms of anything that we're putting in the ocean without looking at the benefits.
So a couple of thoughts on that. The first one is, let's be clear about what the BBNJ regime does. It doesn't have the ability, except within the areas where there's an area-based management tool or marine protected area, to regulate activities. The environmental impact assessment process is like the U.S. process under the National Environmental Policy Act, which is it's a process. It's the ultimate decision on whether to go ahead with the activity rests with the state that is got jurisdiction or control over the actor. Okay, so what does that mean in these terms? It's not, the environmental impact assessment process is not a complete risk governance regulatory program. Okay, it's part of that, but I think it is an important part of it. And I think what I would take a little bit of issue with Will's attitude towards EIAs, and I'm rather fond of environmental impact assessment because I like information and they're great to read. If you've never read one, go grab one off the EPA website and read it. We actually tried to get language into the text. We didn't succeed, but in the treaty text, it says that alternatives to the proposed action should be considered. What we didn't get in was a no action alternative. And that's where what you want to have in, Will, can come in. The proponent of the project can say, look, if you don't do this, you're going to fail to sequester this much carbon. This is our degree of certainty that we'll achieve that. And so on. So I think it's possible to make the case for the positive benefits of the project, but if a no action alternative is included, which of course it can be voluntarily. There's one other element. There was a lot of discussion about how much detail to have in the text about environmental impact assessment. And in the end, it's a long section, but it doesn't have full detail. And there's the room for the scientific and technical body to develop further guidelines and have those adopted by the conference of the parties. So this is something that could be developed, and there might be some room for more creative engagement there. And I'll say, be in touch with us at the International Union for Conservation of Nature or the High Seas Alliance or other civil society groups or governments who are working on implementation and are already thinking about these issues, because we want this treaty to come into force, and when it does, we want it to be ready to hit the ground running. So these are really useful issues to be talking about now.
A couple of other implementation related questions then. So the treaty requires 60 states to ratify before it comes into force. Can you give us a sense of when that might happen? And is there likely to be some application of the agreement in the interim? What can we expect this agreement to do for the field over the next couple of years?
Shall I take that one? So I mentioned that 81 states plus the EU and Palestine have already signed it. That's the sort of the text gets adopted, countries sign, when they sign the treaty, it doesn't make it apply instantly, but they do, under international law, incur the obligation to, quote, refrain from acts that would defeat the object and purpose of a treaty once it's been signed, and unless the state makes it clear that it wants to withdraw its signature. So that already gives a little bit of force to the treaty, okay? We are hoping, and in the treaty text, it's going to require 60 states to ratify it. That's the next step. You take it home to your own country, you get your legislature or your president or your monarch or whoever in your legal system has the authority to say, yes, we're going to become a party. So that's ratification, acceptance, or approval of the treaty. And then you send that document to the depository, which is the United Nations Secretary General, and that's it. Then you wait, you get 60 states do that, the treaty enters into force. Okay, at that point, it becomes legally binding on all the countries that have ratified, accepted, or approved it. And we're hoping that will happen by 2025. That will be the next UN Ocean Conference. And there is a big, strong commitment to seeing this treaty become effective by then.
Thank you. Okay, so a few other questions here about implementation. So there's one question which notes that there was discussion of an annex during negotiations of the treaty, discussions of an annex on marine geoengineering that apparently was ditched. Simi, do you have any background on that? Given that that annex is gone, where does that leave the relevance of this treaty for marine carbon removal? And then anything, Will or Simi, you can say about interactions between this treaty and other existing treaties that also have something to say about marine-based carbon removal?
Yeah. So there were discussions of a lot of different possible annexes, including a whitelist or blacklist for environmental impact assessment activities that have to have one or are exempt from having one. In the end, the decision was made in part because of the difficulty of negotiating the annexes, honestly. I mean, look how long it took to take it the basic treaty. So I don't know. I wasn't. I mean, I was in the room for basically all of the negotiations except towards the end. But of course, there's a lot of private bilateral discussions between states. So I didn't hear everything. I don't know. I think it was just the geoengineering part disappeared along with the black and white lists, to the best of my knowledge. It that doesn't mean anything about the applicability of the treaty. It would have clarified things, but it also might well have created problems by reflecting the technology at the time, like in 2018, which is, I think, when that came up. So it doesn't, that's another reason it doesn't make a lot of sense. The treaty is a general treaty that, and this is one of its virtues, it can address any activities, seasteading, as well as climate interventions. So yeah, it neither limits or permits the treaty to regulate the kinds of activities we're thinking about. Will, why don't you do the next part of that question?
Yeah, so the treaty has a number of provisions that contemplate cooperation with other treaty regimes or other pertinent sort of bodies. There's a provision that says it's to be interpreted and applied in a way that doesn't undermine existing legal instruments and bodies and promotes coherence and coordination, kind of standard boilerplate language. It at the same time doesn't provide anything specific, right? And so that's something that's going to have to be worked out, right, in what we call polycentric governance, right? And we have a mixed bag at the international level in terms of doing that. I think when it comes to what we generally denominate marine geoengineering, the London Convention and Protocol and the Convention on Biological Diversity, both of which intervened in the face of ocean iron fertilization experiments in the last decade, have a pretty good track record of coordinating their activities. The London Convention and Protocol have often referenced, for example, the extensive reports that the CBD has done on marine geoengineering. And I think the Convention on Biological Diversity and its resolutions kind of let the protocol and convention take the lead in establishing the initial contours of what kind of activities should be allowed and under what circumstances. And so they've embraced the scientific requirement of scientific research only and risk assessment, and that came from the protocol and convention. And so I thought that was an example of cooperation between them. It's always hard to know, though. I mean, you have a lot of regimes like the whaling regime that has often had a poor record of cooperating with fisheries regimes and others that would be pertinent to its activities. And so it's hard to know what will ultimately happen in the future. But there's certainly language that aspires to that, and there's certainly been participation by these other regimes, both on geo issues but more broadly on other ocean issues that may portend more cooperation in the future, because clearly they understand the provisions of the treaty and kind of the implications in terms of what they do. But I think it's to be determined. What do you think, Simi?
Yeah, no, I think that's a fair description. This is the kind of thing that it remains to be seen. And tell you, frankly, I heard in the years when we were negotiating the treaty from other people who worked for other secretariats, not the Convention on Biological Diversity, which has always worked closely, and the negotiators participate in both. But some other regimes, it's like, no, this has nothing to do with us. You go do your thing and don't get in our way. And that is not what they're saying. I mean, once the text was adopted, they're like, okay, we'll talk to you. we'll have to figure out how to do this. So, yeah, I think it'll evolve over time.
So just to kind of continue to test my understanding here and to pull in again a couple of questions from the list. Is there any distinction you can draw either in the BBNJ text or in the interactions between these different regimes? Any distinction to be drawn between research and deployment? If a startup company in the United States says, we just want to test something out in the open ocean, would that be seen differently by this regime than we're ready to deploy at this much larger scale? I can just imagine folks starting to wonder, is the landscape getting over-regulated, or is it getting confusing now for folks who are just trying to advance the technology? How do we make sense of those sorts of issues?
Well, for the EIA provisions, is it going to trigger the threshold? So you do the screening, and then is it going to trigger the threshold for an EIA, which is, like other EIA processes. I think that's the main consideration there. SEA will, I think, that's where we loop in, so we don't get lots of research projects that have a cumulative effect. And there's cumulative effects analysis in the EIA provisions too.
Yeah. I think one area where there could be confusion, right, and there will have to be clarification is the London Convention and Protocol, clearly in the context of ocean iron fertilization, and it looks like maybe now in terms of ocean alkalinity enhancement and macroalgae harvesting and maybe upwelling, would impose the same requirements as they did for OAF, which would limit it to non-commercial operations and risk assessment, whereas the BBNJ doesn't really, certainly in the EIA provisions, right, that are procedural, certainly wouldn't preclude one from engaging in commercial operations in the context of MCDR, right? And so that would be something probably that they would have to work out. The same thing with the CBD, right, which doesn't contemplate commercial operations. I don't think the BBNJ on its face would preclude that, right? And so I guess that's one area I could see that there might be clash and a need to reconcile.
Yeah, there's part of the strategy here, at least to my mind, is that the transparency provisions allow other measures to come into play. So, for example, let's say an EIA shows that a species protected under the Convention on International Trade in Endangered Species is going to be affected, then that convention would come into play. We don't have as many of those kinds of environmental laws for the high seas as we do domestically. But that should be part of how this plays out. So it's the whole treaty system that would affect, and the political system. And there are cases where a treaty didn't prevent a state from doing something that was environmentally damaging, but the treaty made it clear that the state was going to do that. And then other countries could say, oh, you want a trade deal with us? Then don't do that. Or you want a fishing license? Don't do that. And it's worked out that way. So the whole system, the international system, is a lot more complicated than just looking at the treaty text and saying, what's it say? Which
you just happen to have sitting next to you, which is not a great surprise.
As it happens. And the law of the sea convention. Never leave home without it.
There you go. So on the transparency components of this, there are a couple of questions about the clearinghouse mechanism and more broadly about transparency. And so you started to address this one question to me. Are there other examples of a clearinghouse mechanism? What can we expect out of the BBNJ? What is this going to look like? And then another question for those who work on the business side, potentially, or on the development side of marine carbon removal. How do confidentiality provisions around technological development get accounted for in transparency mechanisms?
Yeah. So I'll take the last one first, partly because my brain latched onto it and I forgot the first question, so you'll have to ask me again. On the confidentiality issue, that's another one that's one of my favorite topics. There is a provision that allows for non-disclosure of information. It has to be indicated, if in a particular context, like an EIA or whatever, it has to be indicated that there is non-disclosure, that it's been redacted. And there's different kinds of non-disclosure motivations too. So sometimes it could be for conservation purposes, for example. But there is a significant risk. I mean, it's understood that for companies or for scientists in the marine genetic research component, where there's a lot of transparency, that for you to do your work, you need to have some space to get the intellectual property out of it, which is your reward, whether you get profit or reputation or whatever it is. But it's also important that that not be abused and that there be adequate information. So it's that'll be a little bit of a tension area, I think, as these things evolve, but that's life. What was the first question, Simon?
Any other examples of clearinghouse mechanisms?
Oh yeah, I'm sorry, I don't have them on the top of my head, but if you go to the High Seas Alliance website, we actually did a paper on clearinghouse mechanisms I think it should still be posted there. And I can send you a link. There are a number of them. I think in this case, my own view is that there are so many different kinds of information that need to be put into the clearinghouse mechanism according to the treaty text, that it's not going to be one thing. It'll be you linking up different ocean observation systems and reporting databases. And I'm going to stop there because that's another subject I could go on for a long time about.
Yeah, one thing I'd add about intellectual property and non-disclosure agreements is it should be remembered that the treaty doesn't operate in a vacuum, right? It grows out of the Law of the Sea Convention, and the Law of the Sea Convention has a lot of pertinent provisions on marine scientific research and deep sea mining, where those kind of issues have arisen. And so there's a lot of standards and norms that have been established that try to create a balance between transparency and protection of intellectual property, and they're often in tension, as always is the case, right? But in my mind, there hasn't been kind of a roughshod running over of protection of intellectual property, but at the same time, it hasn't been used as a shield in a way that I think totally obviates the value of these transparency requirements. So I think they'll have to work those things out on an ad hoc basis, but they have some precedent and experience for doing so within the regime.
Yeah, I think that's right.
Thanks. So we have roughly 5 more minutes. A lot of questions have come in. Let's just stay with private sector issues for a moment. So one question here: if a country has no implementing law for the treaty or doesn't develop an implementing law, does the treaty still apply to companies based in that country? And then another related question: how do you determine if a company is based in a country? Does it come down to the flag flown by a ship conducting activities on the high sea, or is there something else that we need to be attentive to here?
My favorite example there, it's a complicated question that's going to best be answered in court, in litigation. But so generally, the simple answer is, if you know where your company is incorporated, and that would be the obvious country that has jurisdiction or control over your business. However, if you're incorporated in one country, but all your assets are in another country, there's the piercing the corporate veil, there's a lot of complicated things there. But what happens if the country has no implementing law? Well, it would seem like maybe you're not subject to any of the rules, mainly because how are they implemented, right? If it's got to be done through domestic courts. But here's the thing. There was an idea, the US isn't party to the Law of the Sea Convention, and it's not, therefore, part of the international deep seabed mining system, and it can't benefit from the rule. Companies incorporated in the US and trying to operate out of the US aren't subject to those rules, but they don't benefit from being part of that community. So one US company went to the UK and said, we'll incorporate here because you're part of it, and we don't want to take the corporate risk of trying to sell product into a global market that might be considered rogue. So I think there's good reasons for companies to look for a country with a good, stable legal regime to incorporate their activities in, and look for the level playing field, look for the predictability that you get from good regulation. Don't just look for where you can get away with it, some country of convenience.
Okay, and should we go here? Maybe. So there's a couple of questions here. This is a marine carbon removal focused session, but we've had a couple of questions come in about solar geoengineering or solar radiation management intervention, in particular marine cloud brightening over the open ocean, or stratospheric aerosol injection over the open ocean. Does this treaty apply?
Okay. The question would be, what is the jurisdictional scope of the treaty? Treaty defines what the high seas are for the purposes of the treaty, defines it as the water column and the seabed, the area. It does not include the atmosphere. However, this was a subject that I raised with a number of legal advisors during the negotiation, and the answer I got was that's implied, because the airspace is definitely included in the Law of the Sea Convention. This is a treaty under the Law of the Sea Convention. So then the question is, so what? How does it cover those activities? Well, if you're going to be, you're really going to be in the water for a lot of it, right? Let's say you're going to try to stage some of these activities from the open ocean, then, well, you're in the water. So it's not really a debate then, is it the airspace or not? There is one other thing that I'd mention, which is, there was a request for an advisory opinion to the Law of the Sea Tribunal on climate change under the Law of the Sea Convention. And in the submissions to that tribunal this past few months, there was a lot of discussion about whether greenhouse gases, which are released into the atmosphere from land, constitute pollution under the Law of the Sea Convention. And the vast majority, I think it may have been universal, said yes, they are. So if you're polluting the atmosphere, you're covered by the Law of the Sea Convention. And I think there'd be a very strong argument then, if BBNJ is in force, that it would also apply as part of that treaty system.
Yeah, and I think the fact that the London Convention and Protocol are looking at marine cloud brightening also as under the rubric, it probably will feed into that narrative to some degree.
Okay, Will, anything you wish we had covered that we did not, or any top level thing you want to leave us with?
No, I just think again, to say what I said at the outset, which is that I think ultimately BBNJ could be highly beneficial for protecting the interests of those that might be negatively impacted by MCDR, and also helping to create a cohesive sort of framework that provides guidance for those that wish to engage in it and engage in it in an ethical way. And so I think it may be finally the connective tissue that we've been looking for, at least in the open ocean, for marine research and potential deployment. And so we'll see what ultimately happens.
Any final words?
Yeah, I think that this is a great time to really support ratification, signing for your country, ratification of the treaty, and then really engaging in the activities to start implementing it, so that we're developing, really focus on this cooperation and collaboration opportunity. And think about how we integrate financial investors into this system, because that's obviously, the financing is going to be a critical aspect of this.
Well, thank you both, and thanks everybody who tuned in to be with us. A reminder again that this was a webinar hosted by the Institute for Carbon Removal Law and Policy at American University. You can find all of our materials at carbonremoval.info or at the American University website. A captioned version of this webinar will be available soon on the site. Will, Simi, thanks for your time.
Thank you.
Bye now.
Bye-bye.